Hello, I'm Jeff Ledford, the Chief of Police here in Shelby. I have the honor to talk to you about the Juvenile Justice Reinvestment Act, which is also known as Raise the Age. This law follows years of research, study, and discussion on this topic. Representatives of law enforcement, the courts, juvenile prosecution and defense, human services, juvenile justice, schools, and the victim advocacy community have helped to shape this law. Joining me today via video link is Jackie Green. She's going to help me to make sure that I get the most important legal details right.
Hello, I'm Jackie Green, an assistant professor at the UNC School of Government. Welcome to the Chapel Hill campus. Raise the Age is an important law that will change the way that the North Carolina justice system deals with 16 and 17-year-olds. Starting December 1st, 2019, almost all offenses that are alleged to have been committed by 16 and 17-year-olds will be processed through the juvenile justice system.
For individuals under 16, nothing will change with this new law. If you knew how to process a 6 to 15-year-old before December 1st, you will follow exactly the same procedures you previously followed. For alleged offenders who are 16 or 17, the procedures will be exactly the same as for 6 to 15-year-olds, except for two important exceptions. Can you guess the first one? That's right. 16 and 17-year-olds can legally drive. The law takes this into account. All Chapter 20 motor vehicle offenses alleged against 16 and 17-year-olds must continue to be processed through the criminal system. Make sure you have this concept straight. If a 16 or 17-year-old is alleged to have committed an offense that is not a Chapter 20 offense, they will be processed in the juvenile system. Chapter 20 motor vehicle offenses will be processed through the criminal system. This second exception is an important one. If someone under the age of 18 is convicted in a criminal court for a felony, a non-Chapter 20 misdemeanor, or an impaired driving offense, they must be processed as an adult for all future offenses. This is known as the once an adult, always an adult construct. This change in status from juvenile to adult is permanent and does not change back no matter how much time has passed since the conviction.
Before anyone gets the idea that this will let serious offenders get a light slap on the wrist, the new law also requires that all A to G felonies alleged to have been committed at age 16 or 17 will be required to be transferred to criminal court for adult processing once the juvenile court finds probable cause or an indictment is returned. As we go forward, officers need to remember to follow juvenile procedures for custodial interrogation of anyone under 18. In addition to normal Miranda rights, they have the right to have a parent, guardian, or custodian present during questioning. And that parent, guardian, or custodian cannot waive any of the juvenile's rights. As you know, anyone under 16 cannot waive their rights, but a 16 or 17-year-old can waive their rights if their waiver is knowing, willing, and understanding. And finally, remember you have to follow the juvenile rules for fingerprinting and photographing. This handy Raise the Age job aid has been developed to help everyone through this transition. On the front side is a decision tree to help decide if the alleged offender should be processed through the juvenile system or the criminal system. Below that is a checklist of advice to be followed prior to custodial interrogation. And on the back side are rules to follow for fingerprinting and photographing juveniles with the applicable general statute references.
Thanks for the help, Jackie. I appreciate everyone's work to pass this important new law and your time and attention for this important transition announcement. I encourage all officers to study the job aid. It's really handy to have. And when in doubt with 16 or 17-year-olds, contact your chain of command with any questions you might have. You experienced officers know that this will all be second nature as time passes and we become more experienced with the law. Just take your time to think and reflect before acting with any 16 or 17-year-old after December the 1st, 2019. Thank you and be safe.